The first major federal gun safety legislation in decades is advancing, while a series of court disputes could redefine the scope of the Second Amendment. In California, law enforcement officers, including federal agents, are described as prohibited from enforcing restrictions on magazine ownership regardless of when the magazines were acquired. The discussion surrounding these rules has become tied to broader constitutional questions about firearms and magazines that are commonly owned across the United States. The Supreme Court has been considering cases that could determine whether millions of Americans may legally possess AR-15 style rifles and magazines that exceed 10 rounds. The central issue is whether these firearms and magazines fall within the protection of the Second Amendment. A major challenge focuses on an ordinance in Cook County that makes it a criminal offense to sell, transfer, or possess certain weapons classified as assault weapons. Supporters of the challenge argue that items owned by millions of Americans could become unlawful if the ordinance remains in effect. Debate has also intensified over legal standards such as reasonable suspicion, objective reasonable belief, and probable cause. A 3-judge panel ruled that a state prohibition on magazines holding more than 10 rounds strikes at the core of the right to bear arms. The argument compares a red dot optic to a magazine, claiming that while misuse can increase danger, the accessory can also improve firearm performance. The claim is that such restrictions impose a limit on the right to possess a firearm. Another point raised is that the dispute was not decided on Second Amendment grounds. Instead, the focus was placed on procedural and constitutional limits rather than a direct ruling on the right to keep and bear arms. The timing has drawn additional attention because Justice Brett Kavanaugh previously stated that the court would likely need to address rifle bans in the near future, possibly within a term or two. Plaintiffs, including individual citizens and major Second Amendment organizations, are urging the court to provide a definitive answer on whether semi-automatic rifles and standard capacity magazines are protected by the Constitution. The litigation path began in 2021 when a lawsuit challenging a rifle ban was filed in federal district court in Chicago. As the lawsuit continued moving through the courts, Illinois enacted a statewide assault weapon prohibition in 2024. That action created overlapping restrictions affecting millions of firearm owners across the state. Soon afterward, the Seventh Circuit Court issued a decision that drew significant attention throughout the gun rights community. In a case known as Bees versus Nepville, the court upheld Illinois' statute. The panel concluded that AR-15 rifles were too closely associated with military use to qualify for constitutional protection. According to that reasoning, firearms considered useful for military purposes could be prohibited entirely. Critics argued that such an interpretation would severely weaken Second Amendment protections because many widely owned firearms have origins or uses connected to military applications. At the same time, supporters of constitutional protections maintained that public safety objectives must be pursued through measures that comply with the law. They argued that the challenged regulation failed that requirement. The Supreme Court also issued a major decision viewed as a victory by gun control supporters. At the same time, courts around the country continued examining whether various firearm restrictions were constitutional. On Friday, a judicial panel determined that a law prohibiting magazines capable of holding more than 10 rounds violated the constitutional right to keep and bear arms. Many argued that the issue affects every firearm owner and deserves attention from members of Congress as well. In California, a federal judge concluded that the state's restriction on magazines exceeding 10 rounds was unconstitutional. Questions were also raised about sensitive place regulations. Opponents argued that states cannot classify nearly every location as sensitive. They pointed to outdoor activities such as hiking, asserting that individuals should not be stripped of the ability to defend themselves in remote areas. Legal observers have been watching these disputes closely. The district court, constrained by prior Seventh Circuit precedent, upheld Cook County's rifle prohibition. The court granted summary judgment in favor of the county. Then, in 2025, shortly after the Supreme Court declined to review another rifle-related case, the Seventh Circuit reinforced its earlier position. The appellate court affirmed the lower court's decision and relied heavily on its previous conclusion that AR-15 rifles are civilian counterparts of the M16. Based on that view, the court held that such firearms fall outside Second Amendment protection. At that point, the petitioners brought their challenge directly to the Supreme Court. They are asking the nation's highest court to provide a final answer to a central question. Do Americans possess a constitutional right to own AR-15 rifles and other similar semi-automatic firearms that certain states seek to prohibit? Cook County responded by urging the Supreme Court not to take up the case. The county offered 3 primary arguments. First, officials contended that no conflict exists among the federal circuits regarding whether these rifles receive constitutional protection. Second, they argued that the litigation contains procedural defects because the plaintiffs allegedly moved too quickly toward Supreme Court review without completing the proper legal process. According to the county, discovery was bypassed and admissible evidence was not adequately presented. Third, Cook County maintained that the lower courts reached the correct conclusion on the substance of the case. At the same time, another closely watched challenge was moving through the system. Both the Cook County rifle ban dispute and a California magazine ban case known as Duncan versus Bunt were considered during a Supreme Court conference held last Friday. The Duncan case carries a unique procedural history. The Supreme Court had previously granted review, vacated the earlier judgment, and remanded the case after its landmark Bruin decision. However, like many Second Amendment disputes, the lower courts were accused of failing to properly apply the guidance provided by the Supreme Court. As a result, the case eventually returned to the justices once again. A significant update followed. Both matters were relisted and scheduled for another conference on December 12th. Many people want Congress to adopt measures that reduce crime while preserving the rights of citizens who follow the law. Supporters of the current legal challenges argue that government authorities cannot regulate an individual's possession of weapons intended for self-defense. They also contend that the Second Amendment contains no language allowing bans on magazines or other essential firearm components. A central question remains whether a magazine qualifies as an arm under constitutional protections. Attorneys involved in the litigation argue that if a magazine is recognized as a protected arm, the entire prohibition could be invalidated, opening the door for Californians to purchase high-capacity magazines once again. Gators Custom Guns in Cowlite County maintains that magazines are a necessary and commonly used component of firearms. Based on that position, they argue such items fall within protected constitutional rights. The outcome could also affect similar statutes in other states, because related laws may face comparable legal challenges. Attention has increasingly turned to the Supreme Court's relisting process. Court analytics indicate that petitions receiving at least one relist have a substantially greater chance of being granted review. The numbers are notable. Examining Supreme Court trends between 2016 and 2020, approximately 31 to 43% of petitions relisted a single time were ultimately accepted for review. An additional statistic stands out. Between 66 and 75% of all cases the court agreed to hear had first been relisted at least once. Because of that pattern, a single relist is often viewed as a sign that the justices are giving serious consideration to a petition. There is, however, another side to the equation. When a case is relisted repeatedly, the outlook often becomes less favorable. The Maryland rifle ban challenge recently followed that path. Historically, the more relists a petition receives, the lower the likelihood that review will be granted. Multiple relists frequently precede a denial, sometimes accompanied by a dissent or a written statement from one or more justices. The situation, therefore, remains uncertain. For years, the Supreme Court has generally avoided directly deciding challenges involving rifle bans and magazine restrictions. Several opportunities have arisen, yet the court has repeatedly declined to take those cases. Even so, Justice Kavanaugh's earlier comments remain part of the discussion. Combined with the fact that these cases received a single relist, observers see reasons for both optimism and caution. One relist alone does not necessarily suggest a negative outcome. It may simply reflect careful consideration by the justices. If future conferences result in additional relists, however, many observers would interpret that as a stronger indication that review could ultimately be denied. A major Supreme Court ruling could carry consequences for firearm regulations across the country. The debate often centers on the distinction between a state's authority to regulate certain matters and the question of whether individuals are being deprived of self-defense rights. Some observers believe the courts continue to struggle with how to address these issues. Others point to decisions, recognizing that the Second Amendment protects carrying firearms in public for self-defense. Questions extend far beyond rifles and magazines. Legal scrutiny could affect a wide range of firearm-related laws, including assault weapon regulations, age-based restrictions, magazine limits, and related disputes involving private property rules and foreign property confiscation. For now, existing rules remain in place unless future court decisions alter them. What makes this period especially important is the larger national picture. States throughout the country are monitoring these cases closely. If the Supreme Court accepts review and ultimately determines that AR-15 rifles and standard capacity magazines are protected under the Second Amendment, bans in several states could be invalidated. If the court declines review or rules against the challengers, other states could view that outcome as support for adopting similar restrictions. Attention is now focused on the conference scheduled for December 12th. After that meeting, the next update should reveal whether the cases move ahead, receive another relist, or reach a final determination on whether the Supreme Court will hear them. If you found this update informative, stay tuned for future developments and follow upcoming court actions as new information becomes available.